Hello, my name is Olu Osha. I often talk about American presidents, and today I'm continuing with my discussion regarding the malicious prosecution violating the Fourth Amendment, Fifth and 14th Amendment rights, which is going on in um, Montgomery County Circuit Court, Maryland. And I've done earlier videos in which I discuss, why this is a malicious prosecution. I've done a motion to dismiss video. So, assuming motions went filed, which is the situation right now, motions went filed, and so I'm continuing with ways that I can raise a defense and have the case dismissed with prejudice. So, a dismissal with prejudice is actually called. With prejudice just means that the case is dismissed and the matter can never be brought up again, right, for litigation, for prosecution. Uh, However, the other thing that can be done is to obtain a judgment of acquittal when you go to trial. So, assuming that the state insists that they're continuing with the malicious prosecution in order to protect the cops who assaulted me, right? I've done several videos in which I explain what happened, so that they're going to continue with the malicious prosecution, even though they don't meet they don't have probable cause and they don't have sufficient evidence in order to be able to get a conviction beyond a reasonable doubt, right? They can't get they don't have evidence to prove beyond a reasonable doubt in order to obtain a conviction. And of course, even though it is not in the interest of justice to prosecute, since I was a victim of a swatting, a law abiding innocent man who was a victim of swatting. So, this is how we can obtain a judgment of acquittal. And so, I'm going to get straight into it. Again, I'm not going to elaborate on the statement of facts on what happened because I've done videos explaining what happened. But let me start from May 16, 2023. So, I'd already been May 16, 2023, I'm in my home where I have a right to be. I have rights of usufruct, right? Right, usufructory rights. That means I have a right to enjoy the place I'm renting, the property that's in my name. I have a right to enjoy, peaceful existence, right? In my the place that I'm renting, the property I'm renting. So I'm there, but I'm also waiting for an appointment that had been scheduled for that day at 11 a.m. with the Navy, Lieutenant Devon Blake. So ostensibly, apparently, it was for a Navy General Officers Professions program. They had said they were going to give me a physical and psychological test evaluation to see my fitness to join military intelligence in the Navy, and that's what I'm waiting for. But there's been further investigation by somebody in the DoD who's now subsequently told me this is after all of this happened, right? This I was just told last year by somebody, a law enforcement officer in the DoD, who said, well, that appointment was fraudulent. So, but it is authentic that this person, I don't know if he really is in the Navy, but there was somebody who was posing that they were in the Navy, the Department of the Navy. The name they gave me was Lieutenant Devon Blake. We've supplied the evidence to the state. So that's what I'm waiting for on May 16, 2023, in my apartment. Of course, my computer was hacked. All my electronic devices were hacked. Of course, I'm thinking that, well, this is one of this is one of the tests that I'm going through. Now, there are other things that were going on that I'm not going to discuss right now because I just want to get into discussing some of the important defenses with some of the cases that are going to just nullify and invalidate the case and have the case dismissed, or in this case also, in this instance, to also get a judgment of acquittal that I'm an innocent man, so it's going to be dismissed, by the judge. I'm going to be found not guilty. That's what a judgment of acquittal also does in court. It could be done by a judge or the jury, a judgment of acquittal. So I'm waiting. All of a sudden, I've been falsely locked up in my apartment. My peephole has been blocked. I live alone in my apartment. I've lived there for 2 years, right? The apartment is 2301 Glen Allen Avenue, apartment 503, Silver Spring, Maryland, zip code 20906, where I was living alone. I was in the proper place. The lease is in my name, right? So, but my people had been blocked. Um, I'd been wrongfully locked in. At some point, there was a band holding my door. I couldn't come out. And there's a drone hovering at my window. And then there's a large police presence in the parking lot, And so I'm alarmed, right? It's supposed to be some kind of training exercise to join the military intelligence that I was scheduled for that under by a Lieutenant Devon Blake of the U.S. Navy, and it was supposed to be for a Navy General Officer Professions program. This is what I was told, and so I was curious to want to find out. So initially, I'm thinking, okay, well, this is all part of what's going on. So I'm thinking this is staged. Of course, it's frightening. But it's also intended to gaslight me. So I'm being gaslighted, right? I've done a video talking about what gaslighting is. So I was being gaslighted. By the way, if you gaslight and it leads to injury, it's actually a crime in the state of Maryland. So I was being gaslighted, and I couldn't come out, and so eventually, uh, eventually when I was let out, I see a troop of cops, and while I'm this, because I try to get a knife to try and cut off the band, and I have no idea what's going on. It's confusing, and I've been gaslighted and so scared. And of course, there was also an effect, right? I found that I'd been drugged, but of course, this is evidence that the state or whoever the agents doing this, and there's state actors involved, they've hidden this. So I'd been drugged, but again, I come out, right? I come out and I see, wow, there's a troop of cops, not cops, but people in riot gear. I don't know who they are. And they're pointing guns at me, right? And so, they eventually tase me, shoot me in the head. That's how I get those stitches there. The scars are there now permanently, right? So I get tased, and that's when I realized, oh, this is not a joke. It's not a hoax. Because all the while I thought, okay, this is a joke, and you can see it in the body cam. I'm saying, cut it out. I'm calling the guy name of the guy, Lieutenant Devon Blake. But eventually, at some point, I'm raising my hands anyway in surrender, and I'm disabling the knife in my hand because they're guns. They're guns being pointed at me by about 30 or 40 white cops, right, in the hallway. And there's nobody, none of my neighbors has come out. So that's part of what's confusing me because I'm trying to figure out how did they pull this off? Like, is this really a training exercise or am I being set up? So I have no idea what's going on. But of course, there's no criminal intent there. I'm not trying to harm anybody. I'm not trying to be violent. So now let me get into the defenses. So this is what happened. And then I'm tased. I'm injured. Eventually, I've talked about what happened. I've done videos just establishing how I was removed from my apartment, gassed, taken to the hospital, and then from discharged at the hospital, I was arrested, and then based on trumped up charges. And the charges were there's six. They kept doing piling on cases, piling on charges, and they're moving about different charges. They first start with false. 5-degree felony assault charges. All those were dismissed. That case number was D06 uh, CR23002968. All of those were dismissed. And then there was a transmittal to the circuit court for 1 second-degree assault. That was what was left. And then that case number was C15CR230000731. And then, a judge, after she stated that a bill of particulars had to be established because the person who, there was one, it wasn't established who it was that I assaulted. And the person who said I assaulted him was a police officer, Jeffrey Ray. When they checked his body cam, it was established that he was the one who shot me in the head. I'm backing him. He's about 20 feet away from me. We don't see any assault. There's no sign, any indication that I'm assaulting him. So we asked for a bill of particulars. Judge Rachel McGuckian, she wanted a bill of particulars. This was October 26, 2023. Instead, the prosecutor at the time who filed, the false charges, claiming that the only reason she filed the charges actually was she realized I was the victim in that assault where the police had no arrest warrant, right? And she said she only filed the false charges in order to use it as a mechanism to force me to go and do a mental health evaluation and take treatment. That's what she said, which violates my 14th Amendment, equal protection of the law, and my zone of privacy rights. I was in my home. I have no mental illness, no history of mental illness. So it was clear that the state of Maryland was participating in framing me, and Thiazomalt filed those charges as a bad faith malicious prosecution. I've done a video explaining that. That's not what I'm going to address now. But so she piled on charges on October 31, 2023, and then brought 6 additional charges, 3 first-degree assault charges, 3 second-degree assault charges, right? They're misdemeanors in the state of Maryland, but each second-degree assault, even though it's a misdemeanor, it carries a maximum penalty of 10 years, and then she filed an additional disorderly conduct, right? Disorderly conduct is a misdemeanor in Maryland, carries 60 days maximum penalty, and there's a reckless endangerment. That's also a misdemeanor, but it carries 5 years maximum penalty in the state of Maryland. And there's also intent to injure with a dangerous weapon. That's also a misdemeanor in the state of Maryland. It has a maximum penalty of 3 years. So those are the piled on charges that the state has established against me without any evidence. And this is how we can defend them to get a judgment of acquittal, right? So it's bad faith prosecution, but it's up to the state to continue. So my attorney has already asked that, look, there's no evidence, they need to dismiss these cases, but the state has insisted. The state of attorney, of course, is John McCarthy, and it's a malicious prosecution intended to obstruct justice, right? And also to prevent the prosecution of the rogue cops who assaulted me without an arrest warrant. And these are the defenses. Now, let me get into it. So first of all, we can have it dismissed because it was a mistake of fact, right? A mistake of fact. I've explained what a mistake of fact is. How was it a mistake of fact? And so, because, there was no intent, right? In order to establish that a crime was committed, the state has the burden of proof beyond a reasonable doubt, and they have to establish at least 2 elements. One, actus reus. Actus reus is the criminal act, the action itself. If it's assault, if it's a battery, then actus reus will be the hitting, right? The actual hitting of somebody, right? The physical action, the voluntary physical action. So actus reus, one, or if it's a intent to frighten, it will be a threatening act. That will be the actus reus. And they also have to establish mens rea, which is a criminal intent, so that they had a guilty mind in order that they intended to commit a crime. So that's where mistake of fact negates that criminal intent. So if it's a mistake of a fact, there's clearly no mens rea. There's no criminal intent, because I was waiting for what I thought it was. I thought it was a training exercise that I was scheduled for, right? And there are cases that support this, right? People versus Lawson. It says that if it's a general intent crime, right, then the belief, so long as the circumstances exist that can be proved, right, and if they're true, to form a basis of belief in the actor, the defendant, right? If it's a general intent crime, then his belief, right, has to be reasonable, right? You can think about it that considering the circumstances and the narrative I've given, the facts I've established, that, well, I was scheduled for a Navy general officer's program, a military exercise, and I thought that was what it was. So I thought we were play acting. I thought it was a hoax. I thought it was a joke. I thought we were play acting. I thought I was being punked. So that can be deemed as reasonable. Some people might think it's unreasonable. Again, in People versus Lawson, even though if it's unreasonable, then it doesn't have to be reasonable, right? That belief that the defendant had, it doesn't have to be reasonable for a specific intent crime. And in this case, it appears to be a specific intent crime because there was no battery, right? There was no, all the state can probably try and prove is an intent to frighten, assault, right? And so there was no, in an intent to frighten assault, there's no battery, right? It's just an intent to create fear is all the state can attempt to prove, because there's no battery, right? There's no physical harm. There's no bodily injury. the best they can establish is that, well, the act of the defendant attempted to create fear in the victim, the alleged victim. In this case, it's police officers who didn't even have an arrest warrant, who were violating my rights, right? Because that's my home. So the other thing is there's a case called Ingram versus State, right? That also says that, well, when there's no mens rea, when there's no criminal intent, right? It should, where you can't establish that the actor, the defendant, had a culpable mental state, right? To establish, to create criminal intent, to form criminal intent, then it negates any appearance, any threatening act. It negates it because there's no mens rea, there's no criminal intent. Here there was a mistake of fact, there was an accident, right? I mistook what was going on. It was accidental, right? And the other thing that can also be established is um, the state I was in, which was induced by the government, and that's I was in a state of fright, right? So I had been gaslighted heavily and so much that I was so frightened that my actions were involuntary, right? And that negates the actus reus portion, right? The threatening act, the actus reus for intent to frighten, has to be voluntary. So if I'm in a reflexive state, that's a flight or fight state because of gaslighting, right? That's an involuntary state, right? My actions are not voluntary. If I've been drugged, like I said I was, if I've been drugged, I'd noticed I'd been drugged, I'd actually told a friend and sent an email May 15th that, oh, it looks like I've been drugged, because this is something that the state orchestrated, right? The state and rogue agents of the Navy, it orchestrated this. I've done various videos establishing this, right? And so I'm not going to get into it. Investigations can demonstrate what I'm stating as well. So these cases, Ingram versus State and People versus Lawson, they negate the criminal intent because, one, I don't have a culpable mental state. I don't have the criminal intent. And of course, there's the mistake of fact, like it's like accidental, it's mistake. So I have no criminal intent. People versus Lawson. So that negates any criminal intent. So it's because of that, uh, that's a solid defense. Furthermore, um, there's also another defense that we can also establish as the defense of um, necessity, and we could use Allen versus State, right? Defense of necessity. That's another. There's another case for that. Allen versus State. Defense of necessity says that, look, if the defendant is in such a state, right, that their life is in danger, right, and they had no other reasonable alternative, right. In this case, I'm in my home. I'm in fear that people are trying to kill me. That somebody has pretended that, well, they're giving me a training, and what they're really trying to do is they're trying to kill me, right? And I have a reason to fear this, right, because of the nature of my job. As of that day, I was an auditor in the Department of the Navy, holding a top secret TSSCI clearance, and I had been secretly reporting fraud of senior executives. I'd reported fraud and misconduct of senior executives, and these were actively under investigation, including senior leaders. All right, I'd reported misconduct to the Auditor General of the Navy, Dunjet L. Gilmore. Right, so I had reason to fear for my life. I had been threatened by people I had reported, right? And these people worked closely with Naval Criminal Investigative Service because I'd been supporting Naval Criminal Investigative Service. So they worked closely with the intelligence community. And I knew they had the means, the capability of actually manufacturing a crime, making me look like I'm a dangerous, threatening person, which they did. And they can subsequently make that as pretext to eliminate me, right? And they can actually come and be pretending that they're cops. So on that day, right, to, I had no reason not to believe that my life was in danger, that the people who had locked me in, falsely imprisoned me, were violating my constitutional rights. That maybe they were not real cops. In fact, this has been done before. I read the biography of Barry Slotnick, who was the defense attorney for the Gambino crime family boss, John Gotti. John Gotti had actually once dressed like he was a cop in order to go and kill his targets, right? He dressed like he was cops. So the mafia used to do that in the 70s. They dress up like they're cops, like they're law enforcement, because they want to, have access to a place where their victim is, and they'll kill him, right? Or they could pretend, create a false arrest, and they'll kill their victim, and they're gone, right? So I had no reason, right? So given somebody who reads like me, I read a lot. I had no reason not to think that, well, these people who were committing crimes, who had falsely imprisoned me, maybe they were pretending that they were cops or law enforcement, just there to try and kill me. So I have the defense of necessity. So defense of necessity has four elements that have to be met. That the the evil I'm trying to avoid, it's greater, it's greater than the offense, right? So I'm charged with defense of offense of disorderly conduct. So I'm screaming, right? That's because I'm trying to get my neighbors to come out and assist me, right? So I'm trying to avoid execution by people I think are rogue cops. They're pretending to be cops, or they're rogue cops, right? They're there to really kill me. So I'm screaming. So that's one. Second, I have no reasonable alternative. All my electronic devices had been hacked. My phone, I couldn't call the police. I was getting a circuitous loop. Um, my computer was hacked. I was locked up in my apartment. When they eventually removed the ban and I came out, there were no neighbors around. And of course, all their troops, just cops, blocking my exit. And this is my home. So they're violating my Fourth Amendment rights. So I was under false imprisonment. So I had to scream. I had no other alternative. There's a drone at my uh, windows illegally surveilling me and harassing me, right? Nobody has shown me an arrest warrant or a search warrant, right? So I had no other alternative. And the third is the harm avoided is not disproportionate to the harm caused, right? And that's the case there, right? And then the fourth element is that once that it wasn't continuous. I once I had I was able to stop the what I've been alleged, what it is alleged that the alleged crime I'm, said to have committed. I stopped it once there was no need to continue. So that's the defense of necessity. It negates any criminal activity or offense. Defense of necessity. And then there's also the entrapment issue, right? So for entrapment, I need to be able to establish that I'm a law abiding citizen. You need to be able to show that you're a person of good character and that you would not have committed the alleged crimes which the government is saying that you committed, had the government not induced you, because you're an innocent person, right? In my case, so that's where I get to establish my character, right? I'm somebody who has at least 4 university degrees. I'd never been arrested in my life. I was actually holding a top secret TSSCI clearance. Um, I'm a law. I have a law degree from George Washington University Law School. I pulled myself up by my bootstraps. I was an usher at my church. I'm a law-abiding person. Never been arrested. No criminal record. Actually, even working for the DoD, for the federal government, right? So there was actually a wrongful assault on me, right? So, but I'm not going to get into that right now. And so I was not committing any crime. There's no criminal conduct in me. I didn't have the propensity or the predilection or predisposition to committing the crime I'm being accused of being committed. And without the government's inducement, right, without the government's actions, I would not have committed these alleged crimes, right? So it's not an admission of guilt. It's not saying I committed it, but I'm giving the government two things to now do. Apart from being able to provide evidence beyond a reasonable doubt that I committed a crime, then the other thing is they have to be able to show that, well, I had the predisposition to commit the crimes in the first place. So I'm now giving them double work to do. So I had no predisposition for crime, and that's established in. Um, there's a case that supports that. There's State versus Doran, and of course there's Torres versus State, right? So Torres versus state, that means the criminal intent was actually in the government agent's mind, the police officers who manufactured the idea of going to get an emergency evaluation petition, which I was unaware of. I had no mental illness. They planned on gaslighting me to make me freak out. That was the objective, so they could have pretext to kidnap me under color of law and assault me and remove me from my home where I had a right to be. They had no arrest warrant. So it was a government that created it, right? So that's Torres versus state supports that, and state versus Doran. Those are states that support entrapment. So entrapment is a defense. The government did something that was illegal. Remember Oliver Wendell Holmes's words. I've done a video where I talked about it. It says that it is, it is a lesser evil that some criminals escape than that the government play an ignoble role, right, in violating the constitutional rights of law-abiding citizens. And this is what happens, right? So that's that regarding entrapment. Additionally, saying that because the government used entrapment, they violated the Fourth, Fifth, and 14th Amendment rights. Why do I say so? The Fourth Amendment, this is how they violated the Fourth Amendment rights. And the cases that I would reference would be there's Camera versus municipal court. There's also Payton versus New York, right? These are Fourth Amendment cases. And the way I'm going to be able to show this, remember, let me recite what the Fourth Amendment is again. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched or the people to the persons or things to be seized. Let me repeat it again. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. No probable cause, no arrest warrant, right? So all of these were violated. Now, the reason why I'm saying the Fifth Amendment, my Fifth Amendment right was violated was because the the entity, the government agency, the government organ violating my Fifth Amendment rights was federal. That's the Navy. Navy actors, the people from the Department of Defense or the people from Naval Criminal Investigative Service, right? They pretended and manufactured this hoax that I was a threat, a danger, and I needed to be removed. No arrest warrant, all a fabrication. So they fabricated a crime, manufactured a crisis which violated my rights. My Fourth Amendment, I had a right to be in my home. I was not committing any crime. There was no probable cause. They manufactured a crime, so they created entrapment, right? So I'm saying Lieutenant Devon Blake of the Navy, the reason I have for that, I have evidence from his false, fraudulent appointment on that same day, and also people in the Navy, Kendra Tees in the Navy, HR, and Nathan R. Brown, people I had reported, right? I'd reported from misconduct, Kirsten Riesberg. There are ongoing investigations. I have evidence that they had actually instigated a swatting. So I was a victim of a swatting. A swatting is when somebody makes a false crisis call of a threat or an emergency situation. It's malicious. It's a malicious criminal tactic, and the objective is to generate a large law enforcement presence at the victim's residence. So people from the Department of the Navy, the federal government, orchestrated a swatting. There's evidence for that. So the government has to prove beyond the reasonable doubt that's not the case, right? So that's why I'm using a Fifth Amendment defense. Now, I'm also using a 14th Amendment defense because it applies to the state. 14th Amendment because it was the state police that also participated, right, in a swatting hoax as well, creating a false crisis. The Sergeant Charles Drengwitz on May 14, 2023, after I'd reported an assault for which I was the victim by a neighbor, Germa Shumi, and Jide Warere, a man who's impersonating himself as my uncle, and he's actually my emergency contact at the Department of Navy, right? So they used him. Jide Warere subsequently said, and I have this on evidence, it's recorded on jailhouse phone calls, phone lines, recorded conversations at the jail where I was wrongfully detained. Jide Wariri admitted, he confessed that it was the police that called him and told him to go and file an emergency evaluation petition. They lied that I was in a fight. It was a lie. It was it was a hoax. So it was something, a false crisis, false emergency created by the state police Sergeant Charles Drengwitz and other actors as well. So that's why I'm using the 14th Amendment, because he violated my due process of law. Remember what the 14th Amendment says. The 14th Amendment says the state shall not deprive any person of their rights to life, liberty, or property, right? Shall not deprive due process of, shall not deprive, without due process of law. The state shall not deprive any person of their right to life, liberty, and property without due process of the law. They also violated my equal protection of the law rights. Equal protection, it's also in the 14th Amendment, right, where it says, nor shall it deny to any person within its jurisdiction due process of the laws, which is what happened to me, because I was targeted. There was no arrest warrant, no probable cause. So they targeted me in order to obstruct justice. So it violated my constitutional rights. So the supporting cases for the Fourth Amendment jurisdiction, Fourth Amendment violation would be Camara versus Municipal Court and Payton versus New York, right? So they violated my Fourth Amendment rights. Now, I'm also going to be arguing further, right, that because my Fourth Amendment rights were violated, so it's an illegal search, I'm going to be asking for a suppression of evidence based on the fruit of the poisonous tree principle. And I've done videos describing fruit of the poisonous tree. And in this instance, it's supported by cases like Wong Sun versus United States of 1963, and also from the origins of the fruit of the poisonous tree doctrine, which is a derivative of an illegal search, right? That's the Silverthorne Lumber Company versus United States of 1920, and also the Nardone versus United States case, right? So these are cases supporting suppression of the evidence as fruit of the poisonous tree from an illegal search and seizure that the Montgomery County Police and state actors, the government, conducted against me on May 16, 2023. So the evidence, the police, if the government, if they have no evidence, right, because it was an illegal search and seizure, violating my constitutional rights, then they can't prove their case beyond a new reasonable doubt. If the evidence is, all evidence is suppressed, then the case is, it's going to be dismissed, right? So that's that. But also, um, and specifically, let me address the issue of intent to frighten, because the body cam evidence, of course, that's going to be suppressed, but the police can use their testimony because they were there. They can use false testimony. They can tell a lie about what I did or did not do, or maybe they can lie that I scared them and that's why they tased me. Of course, that's pretextual. So that's what they're trying to really do. They file these false charges. The state of Maryland filed these false charges in order to prevent later lawsuits and the culpability of the police officers who assaulted me on May 16, 2023, illegally, right? If they're actually filing an emergency evaluation petition in the state of Maryland, the law says they cannot injure the evaluee because he hasn't committed any crime, right? You're just saying there's somebody, a judge who's just saying, take this person to a hospital for evaluation. But that was never what their intent was. The intent was to create a false crisis because, one, I don't meet the requirements for an emergency evaluation petition. I was never homicidal. I was never suicidal. This has been established by all psychiatrists that subsequently evaluated me wrongfully, right? At the same time, I had no mental illness. Till today, it's been established. The psychiatrists have said, I have no mental illness. I don't take medication for a mental illness, right? So, despite the fraud, right, the fraudulent, false incompetency to stand trial orders by the judge, right, who has committed judicial misconduct, it's been established that I have no mental illness. So, and then the emergency evaluation petition, which I was not aware of as of that day, right? It was actually a perjured document, so it should be vacated, right? It was a fabrication. My family has gone to court in Nigeria saying Jide Wari is not my uncle, is an impersonator, and everything he wrote was a malicious fabrication, all lies, right? So that is vacated. So they well, whatever happened in my home was just a violation. Now, regarding intent to frighten, I've done a video showing how that is addressed, how to negate the criminal intent or negate that assault charge, the defenses. And of course, there are three elements that have to be proved. I've already discussed that. The threatening act, which is supposed to be the actus reus. I show how there was no actus reus because it was an involuntary. It was at best it was an involuntary act uh, created due to gas as a response to gaslighting by the police, right? So a fight or flight situation is an involuntary and reflex action, right? So there's no threatening. So the threatening act does not satisfy the actus reus requirement because actus reus has to be, the threatening act has to be voluntary. That's one. It can be due to um, diminished capacity. Diminished capacity could be drugging, right? They're involuntarily intoxicated. In my case, my apartment had been spiked with drugs, in likelihood by a federal government agent. The day before that event, there was a soldier in my building. Body cam had, sorry, the CCTV will show a soldier in my building, and my apartment had been spiked with drugs, right? So, and I told my friends. So that dismisses it negates the threatening act. All three elements have to be present. Then the other thing is there has to be mens rea. There has to be the specific intent to cause fear in the victim. That doesn't exist. What defeats that is mistake of fact, which I've discussed, right? It was a mistake of fact, and also an accident, right? So there's no mens rea, or a joke. I thought it was a hoax, so I was responding in kind. I thought it was a hoax, that they were joking. It was a hoax. It was a staged event. That I thought that day was a staged incident because they were all criminal acts that were going on. The false imprisonment, blocking of my peephole, those violate my Fourth Amendment rights. They're illegal acts. And I didn't expect that the government would be committing a crime against a law abiding American citizen who works for the federal government, right? So there was no reason for me to believe that, right? I thought it was a hoax. It was some kind of joke. And you could see it in the body cam, right? I thought it was some kind of joke. So there's no mens rea. And then the third thing is there has to be reasonable fear in the victim, right? Reasonable fear of impending or imminent bodily harm. If you look at that video, um, if you study that video properly, um, I was backing the cops, about 30 to 40 cops, disabling a knife and raising my hand in surrender. And they're about 20 feet, 30 feet away, and they're tasing me, right? So it's hard to say that somebody who's backing 30 cops, somebody who's disabling a knife, the knife is stuck in the wall, disabling it, and he's surrendering. It's hard to say that he caused fear in 30 cops holding guns, Glocks, firearms. In fact, one of the police officers, uh, Jeffrey Ray, he did confess. He said his intent was to kill me. He was a racist cop, called me an animal. He said his intent was to kill me. So it's hard to convince anybody that those 30 white cops holding guns, uh, were, feared that I was going to touch them, right? That they feared an offensive bodily contact, right, from me. So it's hard for them to be able to demonstrate that. So there's no intent to frighten there. Um, right? And there are cases that suggest that, right? And I talked about, I did a video in which I discussed United States versus Acosta Sierra, right? And which it says that the fear has to be there before, the fear of the victim has to be there before the threatening act, not after the threatening act, right? And there's also the case of Barrington Dean Watts versus State of Maryland of 2018. I discussed that, and also there's a case of Smith, right? So all these things, they negate the intent to frighten element, the intent to frighten assault, which is supposed to be a specific intent crime. So the specific intent was not there, because I thought it was a mistake of fact. One, it was a mistake of fact. It was accidental. I had no intent to create fear, and there was no subjective. They have to consider the facts and the circumstances surrounding the alleged victims, the police officers. They created the crime. They staged the whole incident, right? And they came to get an innocent victim. So there's no way that they feared being harmed, being hurt, because they fabricated the emergency evaluation petition, and they worked in collaboration with the Navy, right, rogue agents in the Navy and the government, in order to make it look like there's a straining exercise. The objective was to remove me from my home. So all of these circumstances, facts and circumstances, negate any criminal intent. So there's no intent to frighten assault. So because of all these facts and circumstances I've described, it was obvious that the government engaged in criminal conduct to entrap a law-abiding American citizen, which violates the law. There are cases to support that against that. That's Torres versus State, right, and State versus Doran, and then numerous other cases as well that are saying this is sort of an injustice that's going on, right? Uh, it's a perversion of justice that the state or continue with this malicious bad faith prosecution, and so there's a basis to have a judgment of acquittal that I'm not guilty, because one, there's no crime. We've asked for a suppression of all the evidence based on fruit of the poisonous blooms, fruit of the poisonous fruit of the poisonous tree. I apologize, because we could show that there was illegal, unlawful, bad faith government action, right? We could show that um, there was illegal government action, right? Remember Wong Sun versus United States and Silverthorne Lumber Company versus United States. These support this, that the evidence, should be suppressed, because I was in my home. And of course, I have the castle doctrine protecting me. The castle doctrine, which says the home is my castle. Um, Jenkins versus State, that's a case that supports the castle doctrine. Jenkins versus State, it says that if I'm in my home and I fear a violent act, I'm the victim of a violent act from outside, armed intruders, I'm actually allowed to defend myself up to using deadly force against the armed intruders, right? If I fear bodily injury or death. And this is what I clearly feared on that day. I was in my home, and I was falsely imprisoned in my home. I feared for my life. I was made to fear for my life. And so the Jenkins versus State says the castle doctrine, I'm allowed to use self-defense. So anything that happened was, can be argued to have been self-defense, and it protects me, right? Because I'm in my home. I was where I was lawfully supposed to be in, and I was not the aggressor. I did not create the crime. I was, acting in self-defense. It was the government, and then the person who did the swatting, like the neighbor who lied, who was suborned to commit perjury by the police, right? That's a Germa Shumin 506, and the person impersonating himself as my uncle who made false statements to the police, and he's disavowed those false statements. They collaborated, right, they first assaulted me on May 14, 2023, and then when I did the right thing and reported it to the police, I've done videos explaining what happened, and I had witnesses. My friend was a witness. The police falsified their incident reports, and then suborned Jide, both of them, to go and fabricate documents just to assault me. And that's why just the extreme, the outrageous conduct which they took it to, it made me realize the government, the state, the police, they were just acting. It wasn't a mistake on their part. So there was motive, and the motive was to obstruct justice in and to impede the federal government investigations and the Department of the Navy and DOD, which I was involved with concerning fraud of senior leaders and senior executives. I'll stop here. I think I've covered most of it. I don't want the state this. I don't want the video to exceed this length, and so if I have anything more to add, I will include it. So that's your judgment of acquittal right there. I've covered the very relevant things. My name is Olu Osha, and I've talked about how I've been wrongfully accused through a malicious bad faith prosecution in Montgomery County, Maryland, in order to obstruct justice. I'll keep you posted. Thank you.